Well, good evening, ladies and gentlemen, and welcome to you in the lecture theatre tonight, and also to those online, to this next lecture in our series, which has been focusing on the relationship between the executive and the courts. Many here will recall the lecture we had from Lord Butler 3 weeks ago, from the perspective of a former head of the Civil Service and Cabinet Secretary. On November the 13th, for your diaries, there will be Dominic Grieve speaking from the point of view of a former Attorney General. And tonight we are immensely privileged to have Master Endicott, Professor Timothy Endicott, academic bench of this inn, and Vinerian Professor of English Law at Oxford and Fellow of All Souls, to come and speak on this topic from his particular perspective in academic law. He is the author of, amongst other things, of the text Administrative Law in its 5th edition with the OUP, and intriguingly a book from the OUP in 2000 called Vagueness in Law. We are delighted to welcome you and thank you for coming here, and look forward to your lecture.
Thank you so much, Michael. I'm extraordinarily pleased to be here. It's daunting because of the topic, the executive and the courts and the Constitution. I'm gonna have to talk really fast. Carrie says she'll interrupt me, but she doesn't interrupt people unless they go way over. So I'll try to cover quickly a list of pathologies in executive government that ought not to be put right by courts. There's a bit of constitutional conservatism for you, which I'll try to explain. We have to know what the executive is. It's the branch that's actually capable of throwing the members of the other branches of the state into prison. I was privileged to say hello to Sir Edward Cook on the way up the stairs. He was in prison 400 years ago today. King James I locked him up, not while he was a judge, but while he was a retired judge and parliamentarian. The executive is also the branch that runs the schools and the hospitals. It's prodigiously complex. It involves a vast proliferation of institutions, 23 ministerial departments of central government, 20 non-ministerial departments, 425 agencies and other public bodies, the military, 333 local authorities, county councils, district councils, the police, the Crown prosecution. I've got 10 pages here. I think the National Archives, the Government Legal Department, Her Majesty's Revenue and Customs, the Committee on Standards in Public Life, the Equality and Human Rights Commission. We need these agencies. We need separations of power between the executive and the other branches of government. We also need separations of powers of various kinds within the executive because of its heterogeneity. It's crucial that the Metropolitan Police, a good example of an executive agency, should be independent from the Prime Minister, the leader of the executive. Or how could we have relied on the Met to slap Boris Johnson with a fixed penalty for partying under the lockdown? The judiciary and the legislature are simple by comparison with the executive. Their work has a characteristic binary form. In the judiciary, it's the form of a proceeding leading, if the claim is not dismissed, to the issue of an order or declaration. In the legislature, the characteristic form of work is deliberation over a bill, over a legislative proposal, leading, if it's not rejected, to the passage of a bill. The legislature and the judiciary have timetables. They have vacations. The executive has no timetable. It cannot close for the vacation. Its work has no characteristic form, although there's a proliferation of particular forms for particular purposes. It has no general form. I don't know any way to define the executive, except to say that it comprises all governmental bodies, except Parliament and the courts and tribunals. The executive has various crucial roles in Parliament, of course. The initiation of legislation, especially for revenue and expenditure, is a focal function of the executive. And of course, as a party in so many proceedings in the courts and tribunals. I think the executive is simply the primary branch of government. Judiciary and courts are exceptional bodies that need to be configured to do some specific things in the public interest that ought to be separated from the rest of government. But because of our shared attachment to Parliament, it's common in this country to think of the legislature as the primary institution of government. John Locke saw things that way in his second treatise on civil government in 1690. It's even better than his first treatise. We need the executive because the legislature's laws have lasting force and therefore need perpetual execution, he thought. He grasped the temporality of the executive, which keeps on operating, whereas the legislature just makes a law that has its own lasting force. So it's necessary to have a power always in being to see to the execution of the laws. Was he tricked by the word executive? I think it's a very misleading term for the executive. There's no branch of government that merely executes laws. Executing laws is a crucial, complex fragment of the complex responsibility of the executive branch of government. It doesn't just execute, it initiates. And it needs to respond to circumstances, and not just to unexpected contingencies, but to the community's need for planning and for legislation, for the establishment of a legislature. These are executive functions. As William Anson put it in his wonderful book, The Law and Custom of the Constitution, in 1885, the executive has something else to do besides enforcing obedience to law. The business of government has to be carried on. The executive must be able to do things which are beyond recall, things which were never expressly ordered, perhaps never even contemplated by the legislature. We can use the emergency services as a paradigm of the executive branch of government. They have to act for the public good in dealings with individuals, groups, and the community in general in diverse ways, some of which are suddenly responsive to unexpected needs, some of which call for planning and structured policy making and institution building and community relation building. Serving the public partly by making the community one that responds to the needs of individuals. And that just involves an open-ended, massive heterogeneity of needs and purposes. And of course, so many of those executive agencies that I stopped listing for you are deeply different in function and operation and structure from emergency services. So because of this massive heterogeneity, there's no general answer to the question of how the courts should deal with the executive. I'm going to try to make my job manageable by just focusing on the leadership, the Prime Minister, and the ministers appointed on his or her advice. And my take-home message about the courts and them, the leadership of the executive, is that the courts have a general duty of comity toward the other institutions of government, including the Prime Minister and the Secretaries of State and the other ministers of government, which means that in determining the lawfulness of the actions of ministers, they should show respect for those persons' capacities to carry out their own role and respect for Parliament's capacity to carry out its role in securing responsible government. Please hear me out. I'm not going along with the grain of the widespread tendency among academics and lawyers generally, I suppose, to think that ministers daily earn an attitude of disrespect and antipathy from the courts. It is attractive to think that Parliament, it's democratic, and that's good. And the courts are principled and independent, and that's good. But the executive are the baddies, and our public life is a struggle against them. Not the NHS, but the ministers. Public life is a struggle against them. It's a popular idea that the first past the post voting system plus party discipline gives a prime minister a vice-like grip on executive and legislative power, and courts have to fill the breach and take a stand against the government. The House of Commons is compliant, the House of Lords is powerless, the prime minister is an elected dictator. Well, I can remember Margaret Thatcher, and so I know better. And in March 2023, who can forget Liz Truss and Boris Johnson? You and I can benefit from those two particularly vivid reminders that the Prime Minister depends in real time on MPs who may turn against the so-called elected dictator on matters of policy, that's Truss, on matters of character and conduct. That's Johnson. Those representatives of the people have a great opportunity to make a prime minister vanish when we need it done as a community. We should remember that the courts could not possibly do what we need in those circumstances. It's easy to think that a prime minister's sojourn in Downing Street ends when he or she loses a general election, like John Major and Clement Attlee and Gordon Brown, or when they choose to do something else. I can't think of any examples of a free choice of a prime minister to go and do something else. The norm for British prime ministers is to resign as a matter of political necessity while holding a majority in the House of Commons. Winston Churchill, Anthony Eden, Harold Macmillan. I am going to go through the whole list. I think it's important. Harold Wilson, Margaret Thatcher, Tony Blair, David Cameron, Theresa May, Boris Johnson, Liz Truss, 10 of 16 prime ministers of this country since World War II resigned while holding a majority that would not or could not help them. Every prime minister in this century except Gordon Brown and, so far, Rishi Sunak. These prime ministers are vivid reminders of the acute personal political danger to which the Constitution exposes a prime minister. Your own people will turn on you and go for your throat. It doesn't matter if you have 150 more seats than the party in opposition. The removal van will roll up Downing Street if you don't sustain a sense of credibility in the busy political imaginations of the many MPs in your ostensibly comfortable majority. It's a great thing that the executive is led today in the United Kingdom by a person who is painfully, poignantly exposed to political danger. Doesn't guarantee good government, but it means that we have responsible government. That is, government in which the person with this remarkable constitutional power of creating a ministry, running the country in a certain limited sense, is in the predicament of having to take on board what other people think and want and will put up with, and is in danger if they don't. Lord Judge of Draycott gave the annual legal history lecture for the Selden Society in the Four Inns of Court in November, and his title was 1622, the King's Prerogative, 2022, the Prime Minister's Prerogative, 1622, the King's Prerogative, 2022, the Prime Minister's. You can see where he was going. 400 years ago, King James exercised the prerogative. Today, the Prime Minister exercises the prerogative. And Lord Judge's suggestion was that we face and we should be aware of the potential for arbitrary use of prerogative today. The significant difference, he's right. I think there's every power, there's potential for arbitrary use. The significant difference, it seems to me, is not just that King Charles III cannot throw Lord Reid in the Tower. The difference is that it was so much easier to get rid of Boris Johnson than it was to get rid of the Stuart Kings. That took a bloody civil war. And then another bloodless one. With Johnson and Truss, all it took was, for ministers to start resigning amid a sense of panic about how things looked. Didn't even take a vote in the House of Commons. So the executive power of the UK government is not the prerogative of Rishi Sunak in the sense of a power that he can exercise any which way he wants. This is a fairly recent development, of course, less than 200 years old, really, I think, since the House of Commons became the center of political power and Queen Victoria appointed the leader of the party with the majority in the House of Commons. I don't even think she saw it, by the way, as an obligation under our Constitution. I think she saw it, having read some of her letters to prime ministers, I think she saw it as a shrewd way of carrying out her responsibility, but she had to. There was no choice. And then that gave us responsible executive government, not good government, but responsible executive government, this predicament that the prime minister has to respond to other people's views. In an article in the London Review of Books last year, Professor Conor Gearty argued that the courts ought to be much readier than they are since Lord Kerr and Baroness Hale stepped down to impose on government a just approach to social welfare spending. Some might say that's a matter for Parliament. Professor Gearty wrote, "Many judges over the years have realized that parliamentary sovereignty is an empty shell, that Parliament is a creature of the executive." He wrote that before the downfall of Boris Johnson and the downfall of Liz Truss. We, with those prime ministerial fiascos in our memories, it's perhaps easier to see that the situation is precisely the other way around. The executive is a creature of the House of Commons. But this was already obvious through Brexit. Theresa May, I imagine, would utter a hollow laugh if you told her that Parliament is a creature of the executive. So with respect, I think that Professor Gearty might better have said that any and every failure to secure justice and social welfare in this country involves a failure of Parliament. It's Parliament that has been and is at fault, and the voters too, of course. And so you see, I'm not saying everything's okay with UK social welfare policy and administration. I'm saying that in the general election of December 2019, we didn't get a Parliament that is the creature of the executive, but an executive that's the creature of Parliament, and there is no constitutionally available basis for securing good social welfare policy in this country, other than through the pursuit of a platform for government with the support of the House of Commons, and the courts can't solve deficiencies in the decisions about social welfare. So note that, I'm not trying to say that courts should leave control of ministers to Parliament, far from it. The House of Commons cannot make up for failures of legal control over government any more than the courts can make up for failure of political control over government. Let's take habeas corpus as our paradigm. Not available to Sir Edward Coke in 1622. Suppose the Habeas Corpus Act 1640 had never been passed and habeas corpus today were not available for detention ordered by the King on the advice of the ministers, of course. Suppose the constitutional doctrine were that the detainee can talk to his MP and that the House of Commons is the forum to control the executive. That would be the abandonment of the rule of law. So there's habeas corpus as our paradigm of the proper juridification of executive governance. And what I want to do is offer you some paradigms of over-juridification. Some of them actual, but partly hypothetical because I think it is kind of fascinating to think of the clear case where it's not the court's job, even when the executive has gone wrong, to put it right. And I offer these paradigms for you as potential ways of grasping what's at stake when you deal in litigation or as a judge with the hard cases of the proper extent to which the courts ought to make the pathologies of executive governance into their business in adjudication. Here's my first offering of a pathology of executive governance, and I just think it's surprisingly common. I haven't made a list, don't worry, of this. I mentioned that one of the heterogeneous functions of the executive is to present bills before Parliament, and they have a privilege through the processes of Parliament to do this. Why not have judicial review of the introduction of a bill in Parliament by a minister? Maybe I've given some of you an idea. Because if you're like me, you've seen it happen. Bills introduced that no reasonable minister would introduce it. Sounds like grounds for judicial review. And yet I dare to think that you would probably not get permission to seek judicial review of decision. Even though barristers love asking judges to push the frontiers and judges love pushing the frontiers, well, Article 9 of the Bill of Rights prohibits it. Proceedings of Parliament ought not to be impeached or questioned in any court or place out of Parliament. I used to think prorogation was a proceeding in Parliament. In Gina Miller's second case, the Supreme Court unanimously said, no, that's not a proceeding in Parliament. On the contrary, it's being imposed on them from outside. So they've moved the Queen Elizabeth, they moved her out of Parliament and said that was not a proceeding. Could you argue that introduction of a bill, that's not the proceeding in Parliament, is the debate and passage, but we're only asking the courts to tell the minister. No, in Gina Miller's second case, they said that prorogation is not something upon which members of Parliament can speak or vote. So even after Gina Miller's second case, I think you would not get permission for judicial review of a proposal by a minister to introduce a bill, and well, you shouldn't. And that statement, something upon which the members of Parliament can speak or vote, that's the answer. Doesn't matter how bad a bill is. The Constitution's way is for the House of Commons and the House of Lords and royal assent to determine what is to be passed. Now, and that's, I think that's a responsible form of legislative governance. And it would be an over-judicialization. You can imagine, it's easy to imagine all of these pathologies of executive governance being judicialized. I think it would be a mistake. Second one, ministerial appointments, is another hypothetical way of over-juridifying executive government. I'm not aware that it's ever been tried, but I've often thought it was an attractive idea. Suppose just hypothetically that the Prime Minister advised the King to appoint a Home Secretary or a Foreign Secretary who would be a disaster. And it isn't tempting to think that courts ought to defer to some considerable extent on an issue like that to the Prime Minister, and given his extensive discretion as to the merits of candidates. But shouldn't there be a role for judges in securing executive governance that is not averse to, aimed against the public interest? On the contrary, I don't think judges should give judicial review of the appointment. Suppose that Prime Minister sacked a Minister of Government without a hearing. Imagine, like in the famous case of Virgin Baldwin, that there was some scandal that made the Prime Minister think that the Home Secretary couldn't do her job, as the Brighton Watch Committee thought that Charles Ridge could not do his job as Chief of Police. There's no precedent for the idea, except maybe Virgin Baldwin, if you like analogies, that it would be unlawful for the Prime Minister to sack the Home Secretary without a hearing. And I think that the principles of natural justice do not apply as juridical principles to the dismissal of a Home Secretary for constitutional reasons, because of the need, the constitutional interest for the good of the community in the Prime Minister's responsibility for appointment and dismissal of ministers. I think it's a paradigm that helps us to understand what isn't the court's duty, what isn't the court's role. And this is, I think I would say this even in the interesting case, which is corruption. Suppose you could prove that a Prime Minister had accepted a bribe to dismiss a Minister of the Crown. I'm inclined, here maybe we probably wouldn't all agree about this, but I'm inclined to think that even in that case, it might be right for a court to issue a declaration that the Prime Minister had acted unlawfully in taking the bribe. And yet I don't think the court ought to interfere with the identity of the person holding the office of Home Secretary. I think that should be understood as a matter for the House of Commons to control the Prime Minister's wrongdoing in respect of appointment and dismissal of ministers. So some of you might want to juridify corruption in the appointment of ministers. I think even that should be a matter for the House of Commons. Ministerial conduct. Here, I won't give you a hypothetical case, but a real one. I think it's a useful paradigm of the over-juridification of executive government, and it will open up for us a wider issue of the role of law and politics in the conduct of ministers. And it's a case that some of you will have read, brought by the Gulf Center for Human Rights, advocacy organization that campaigns for respect for human rights in Persian Gulf countries. David Cameron amended the ministerial code being a statement by the prime minister, successive prime ministers, with different forms of precedents before Tony Blair, but Tony Blair published it as a code, as his statement of his expectations of the standards of conduct of ministers and the ways in which they ought to carry out their role as ministers. And it starts out saying that the ministerial code should be read alongside the background of the overarching duty of ministers to comply with the law, including international law and treaty obligations. And didn't he delete the words international law and treaty obligations? And Gulf Center for Human Rights sought judicial review of the decision to delete those words. They said that the deletion, dissing international law that way and evidently telling ministers they didn't have to adhere to international law, breached the principle of legality because there was no consultation, and pursued an improper purpose and was irrational. No reasonable prime minister would take out the mention of international law. Justice Cranston refused permission on the papers for judicial review. And then, and you'll know this, you can go back and ask for an oral hearing, and Justice Mitting declined permission after an oral hearing. Then Lady Justice Arden heard an application for permission to appeal, and she gave permission to appeal, but only if they could argue that the editing of the ministerial code made a difference of substance. And then the Court of Appeal, the Lord Chief Justice and the Master of the Rolls and Lord Justice Hamblin looked at the editing of the ministerial code and said, that doesn't make a difference. They have the duties that they had. And the government is saying that this doesn't make any difference in the obligations of ministers. Well, I think that it's a paradigm of over-judicialization, because in my view, it would have been legitimate for the court to say, you cannot seek judicial review of the ministerial code. There is nothing the prime minister could say in a ministerial code expressing his view and his expectations about how ministers should carry out their duties that would be a matter of law, unless, perhaps, it amounted to encouraging the commission of a criminal offense under the Serious Crime Act 2007. I just don't see why there should be judicial review of a statement by the prime minister of the attitude he takes and the expectations that he has towards ministers. Absolutely on the table for the House of Commons, for them to have authority to throw out a ministry on the basis of what the prime minister says about his expectations of ministers, to ask him hard questions about it. And isn't the House of Commons a potentially useful forum for this country in exposing and challenging sort of flippant editing of a ministerial code by a prime minister who wants to say that we're not all that about international law? But I don't see an issue for a juridical issue. I don't see how anything that a prime minister says in a ministerial code could be unlawful. You know what he says, and when they come into the cabinet room, they have to kowtow to me. So no reasonable prime minister would do it. I just don't see what the country has to gain in the way of responsible government from, my goodness, what a generous day in court the Gulf Center for Human Rights had. 6 judges. And here's a thing about public interest litigation. You can bring a claim with no prospect because there is no genuine juridical issue and there's no ground for judicial review, or you don't have standing, or you're out of time, or all of the above. And there you go, making permission, the hearing for permission into a really rather wonderful, you might say, useful forum for public advocacy in a court, before an independent tribunal, with your lawyers on level pegging with the lawyers for the government of the United Kingdom, exposing and arguing against their attitude towards international human rights law. This I don't know whether to say this is a form of over judicialization, that someone with no claim that is a genuine judicial review claim should get the facility of that forum. I tend to think of it's a necessity. I don't have an alternative to offer for you in which the claims that really aren't matters for courts could be struck out without rehearing, with an oral hearing, asking for permission to appeal, and without an appeal to the Court of Appeal or even to the Supreme Court of the United Kingdom. I think there you go. That's judicial process. There's a lot of judicial process that we need to, the country needs to provide for the purpose of hearing claims with an open mind, without being able to decide in advance that it's not to be considered. The wonderful Wilson case, asking the courts to quash Brexit because of irregularities by the Leave campaign in the run-up to the referendum. They got a hearing with no potential for proceeding to a full hearing. They got a hearing in the permission stage. And likewise, the wonderful Al-Haq case in 2009, Palestinian human rights organization, claiming the British government was violating international law and English law through its support for Israel. Their solicitors were telling them, no, you're not going to win this. And it's still a valuable campaign litigation because of the permission hearing. It's remarkable. And so I just wanted to say, when I'm saying that in these executive pathologies, the court shouldn't be over judicializing things. They're not actually over judicializing things if they give a hearing and actually listen to the lawyers for the campaign group in the permission stage of the judicial review process. And some no-hope litigation is unavoidable. I'm thinking of the reference by the Lord Advocate of the question of whether a bill to provide for a second referendum on independence for Scotland would be within the powers of the Scottish Parliament. She asks the Supreme Court of the United Kingdom that question. The question depends on whether the legislation would relate to the Union of England and Scotland. Legislation providing for a second referendum on Scottish independence relates to the Union of England and Scotland. But the Supreme Court doesn't exercise the discretion it has to not to hear the reference, and it doesn't say, legislation to provide for referendum on Scottish independence relates to the Union. No, what a careful, lawyerly, and extensive examination of the arguments of the Lord Advocate. After which, of course, all of which supports in a lawyerly fashion the conclusion that it's not within the powers of the Scottish Parliament. I think it's an admirable piece of judicial craft to explain, not in words of one syllable, but in several paragraphs with words with many syllables, why the obvious is the case. Pathologies of executive governance appointments to the House of Lords. In Lord Judge's lecture that I mentioned, he disparaged the practice of prime ministers in appointing members of the House of Lords. I have to agree. I think it's a national scandal that prime ministers appoint party donors as members of our legislature. All you can say for the custom, I think, is that it's so bad that prime ministers must obviously feel a political need to make very many patently admirable appointments to the House of Lords. The power of the king to appoint to the House of Lords, which is now, of course, a power on which the prime minister advises the king, has played a really significant role in constitutional politics ever since Queen Anne appointed 12 new peers in 1712 to get a vote, the House of Lords to vote in favor of the Treaty of Utrecht. King William IV was eventually unwillingly constrained to agree that he would appoint new peers in 1832 to get the House of Lords across the line on the Reform Act. In the 19th century, even after that, there was controversy among scholars as to whether it was constitutional for the prime minister to advise the king to that effect, or for the king to act on the advice. But by the 20th century, when George V let it be known that he would accept his prime minister's advice to appoint hundreds of peers to allow his government to get the Parliament Act through Parliament, it was no controversy. That is the thing for the king to do, to act on the advice of his prime minister. Both in 1832 and 1911, the Conservative peers backed down rather than have so many Liberals foisted on them. Well, that's history after the Parliament Acts, I think. The value of that constitutional pressure release valve, I think, is historical. Even apart from any wider reform of the House of Lords, it seems to me that political patronage ought to be eliminated. But here's my point about courts and the executive. The judges, I think, have no legitimate role in solving this problem of constitutional ordering. If you think some of the appointments to the House of Lords ought never to have been made, it does not follow that there ought to be judicial review of the reasonableness or even the propriety of the advice of the Prime Minister's appointment of peers, for which, of course, he's accountable as he's accountable for everything to the House of Commons. Pathology number 5, the appointment of the Prime Minister himself or herself. And here I have a gripe about our Constitution. I do think it's terrific that our constitutional arrangements focus political forces in such a way that a prime minister vanishes when it's all looking pear-shaped to a certain number of MPs. But when that happens, we're all at the mercy of the internal rules of a private members club. I think the political parties ought to be ashamed of this. You'll hear people call the election of a leader by party members democratic. That's not democracy. They're not the demos. And I think, political parties can choose a leader any way they wish for a general election. And then the demos can decide about the candidates that stand for that party. But if a prime minister vanishes, as Boris Johnson vanished, and his party is going to use its majority to appoint a new prime minister without a general election, I think it ought to put the leadership, the appointment of a prime minister, in effect, in the hands of the party's MPs, the parliamentary party, as they call it, whose election, after all, by actual voters, is what gave the party the appointment, the power, the opportunity to appoint a prime minister. And there again, an illustration of my point about the courts and the executive. The courts can't solve that, and you can. The courts wouldn't invent this, I don't think. You can imagine legislation regulating the operations of political parties in respect of leadership decisions, and I don't think that form of that legislative juridification of the process would be advisable either. I think it should be a matter for the Conservative Party, who is the leader of the Conservative Party, and then there isn't a remedy for it in the courts if they do so in a way that's pathological. So our Constitution secures responsible executive government through appointment of a prime minister by reference to representation in the House of Commons. I was trying to phrase that. What is it that happens? Walter Bagehot said that the House of Commons chooses a prime minister, but House of Commons doesn't do a thing. I think it's quite significant. It's the king who appoints a prime minister and does so in a way that is based on representation in the House of Commons. They find out, members of the House of Commons find out who's going to be prime minister. It's obvious if after December 2019, it was obvious who was going to be prime minister. It's determined by a rule, but it's not a decision of the House of Commons. I think that's constitutionally significant. And yet, appointment on the basis of representation in the House of Commons makes it democratic. And then putting the ministers completely at the mercy of the House of Commons, exposing the prime minister and therefore the whole ministry to the political danger that got to Boris Johnson for conduct and got to Liz Truss for policy, that keeps it democratic. The House of Commons privileges the opposition in a way that makes it democratic, more democratic. Means that the House of Commons is not a cohesive body, of course. It's a forum in which the next election is being fought every day. So that arrangement has the virtue of democracy, which I don't think we should overstate. Appointments to courts aren't democratic, or to Ofsted or to the Bank of England, and they shouldn't be. But I do think that democracy is a virtue in the appointment of a prime minister. I don't think this is entirely obvious. I do agree with Winston Churchill's clever adage that this is the worst form of government, except for all the others that have been tried from time to time. And what is it that makes it right that the prime minister, and honestly, I think the position of prime minister is much more democratic than the House of Commons or the position of any particular MP because of the exposure of the prime minister. Why is it good that it should be democratic, the appointment and the continuation in office of a prime minister? Well, there are two reasons, I think. First is that the open-ended responsibility that he or she has on behalf of the community for the general good, subject to all sorts of constraints, rather than for the particular purposes that judges pursue on behalf of the community or Ofsted or the Bank of England. So first of all, it's that general function on behalf of the community as a leader, as a representative in international relations, and as a head of government. It just needs to be democratic. I'm trying to articulate the obvious. We don't have any other way of appointing a person with that responsibility. And secondly, of course, is the simple leverage that it gives to responsible government by subjecting the parties in anticipation of an election to the need for the support of the voters. And that constructs the predicament for the prime minister in a general election, and then the predicament in the House of Commons, in which he or she must respond to the needs and desires and the views of others. That I think that's a good part of our constitution. The House of Commons is the forum for supporting responsible government, not merely because it's democratic, actually, but because of its capacity to respond to the open-ended array of considerations on which the diversity of executive government ought to be assessed. The House of Commons can even hold ministers accountable for obnoxious attitudes and demeanor and personality, all the things that a judge has to try to ignore. If the House of Commons does poorly in its open-ended function, the courts are not a well-configured institution to solve that. Their proper role is different. It has that characteristic binary form, depends on bipolar argumentative contestation, privileging the claims of a person with an allegation of unlawful conduct. A claim that calls for sound interpretation and application of prospective general legal standards. And I hope that these simple points may prove useful in working out hard cases as to the ways in which courts can legitimately and for the public good innovate and respond to arguments on their legal merits and not on their popularity or trendiness, and advance responsible government without fear or favor. So the scope for juridification of executive government is perhaps not, hasn't been fully worked out, and it will be fully worked out in the courts in the years to come. I kind of like the famous World Development Movement case in the 1990s as if you want a paradigm, in my opinion, of judicial creativity, judicial activism, as Lord Butler called it in his lecture earlier in this series that Michael mentioned. The government, in my sense, the executive in my sense, the leadership of the executive, well, I don't know to what extent the Prime Minister was involved, but the Foreign Secretary thinks, I know what we can do. We want to make it attractive for another country to buy British products. Let's use the overseas development budget in that country to encourage it. I think it would have been possible for the judges to say, "Oh, this involves questions of international relations." The legislation itself can be read different ways and allows for economic development in a country, and that's what they did. And instead, the court actually looked at the purpose of the decision and the purpose of the legislation and held the government to the purpose of the legislation. A creative and perhaps controversial and I think admirable imposition of responsible government in a properly juridical matter. So I just mentioned that just to say I'm not saying that claimants should lose when they bring claims for judicial review. I'll wrap up just with my pitch for the Constitution, which I don't want to oversell. I think it's really a surprisingly good one. There's all sorts of scope for you to disagree, and that the scope for us to disagree is actually one reason why I particularly like the Constitution we have. Being somewhat stuck with it, we don't have to agree on it, and that's valuable to this community. It's a value that's not even dependent on the merit of the Constitution. You or I could imagine a better Constitution, but I mean no disrespect to us or the other 67 million people of this country when I say that we could not conceivably agree on a better Constitution. And if we started with a blank page, we would never agree to write the one that we have. This one has this focal merit. It exposes the Prime Minister to political danger and thereby exposes a political party to the danger of retribution for its conduct and its policies. I think that may be the best single thing that we can expect for a constitution. So you see, I'm not putting constitutional idealism very high. I think, I think that's the focally good thing about our constitution. But you see, I'm handing you a form of constitutional conservatism, and you may not like that. And it involves a certain form of tolerance of bad politics. And I just think that every political community needs, ironical and terrible as it may sound, a certain form of tolerance of bad politics. The terrible thing about a constitution is that it's going to allocate power to someone, and that creates the space for bad politics. But I don't think for a minute that I'm making an argument for bad politics or even for political conservatism. This constitution we have is the one that Clement Attlee played like a violin to bring about permanent structural improvements in education, in medical care, in housing, and support for the disabled, in alleviation of hunger and squalor. There's nothing in the Constitution that prevents politics from securing changes like that. But again, there's nothing in the Constitution that attains it. It's only a constitution. It takes politics to attain the public good. And conversely, it's politics, not the Constitution, that messes things up. When the Constituent Assembly of India completed its work on the remarkable document, the Constitution of India in 1950, Dr. Ambedkar, the great leader of the assembly, by the way, having adopted that structure in which the head of government is appointed based on representation in a democratic assembly and can be thrown out by the assembly, having adopted that structure. Dr. Ambedkar said, if things go wrong under the new constitution, the reason will not be that we had a bad constitution. What we will have to say is that man is vile. And I hope that Dr. Ambedkar will be a model to some of you, a brilliant lawyer who went into politics dedicated to not being vile. And I hope that those of you who are training for the bar will take the gifts you've been developing and put them to work in the law in the interests of responsible government. And there's an open-ended space for that, even though I think this space has limits. And for some of you, I hope that, like Dr. Ambedkar, you will find an opportunity to put those gifts to work in politics, where there's room for the more open-ended pursuit, not just of responsible government, which is a responsibility of the courts as well as the House of Commons, but of good government. Thank you. I was going to say I'd be glad to take questions, but no, I'm scared about taking questions, but I'll do it anyway.
No, thank you very much indeed. Well, thank you so much for that hugely stimulating lecture, and I'm sure there will be questions. Could you, there's a microphone will be brought round, and can you say who you are so people online can know?
I'm Gabriel, I'm a student presently reading Barnes. You mentioned the ability of Parliament to fire Prime Ministers and touched briefly on their more limited role in hiring Prime Ministers. Considering that Theresa May lost 3 times the flagship bill of her government, and the King did not call for a new Prime Minister despite her patently not having the support of the House of Commons, clearly the political party has become the 3.5 branch of government, which is the gateway to decisions on appointment without there being a general election. Yet you seem uncomfortable with any kind of legislative scrutiny or oversight, despite their obvious power and key control in the hiring of prime ministers, even when governments ground to a complete halt.
Yeah. Okay, thank you. I guess I see the House of Commons as a forum of contestation between political parties that creates exactly what we need as a community in the way of putting political parties, which are so important to our public life, in a position where they've just got to behave in a way that will sell at the next election. And I think you can see that at work. I'm not an observer of politics really, but even I can see that at work in the processes that led up to the departure of Boris Johnson and the departure of Liz Truss. Resignations, right? Even the party didn't have to do anything. And yet who knows what was going on within the parties. And I mentioned that I think a very significant part of those episodes was the resignation of ministers. And that's of course a part of what's going on in the party. So there's the House of Commons doing its job, not without taking any action, without having a vote of no confidence. And of course, without the country having any legal regulation of how the parties operate, the difficult, painful controversy over Owen Paterson late in Boris's period in office was a remarkable example of the operation of the House of Commons, in which the Prime Minister the government whipped MPs in the majority to support a proposal that looked irresponsible to a lot of people, not just to the opposition. But the leader of the opposition used that situation remarkably effectively in the House of Commons. And the MPs who had voted, as well as the Conservative MPs who voted with as they were told, and those who rebelled, all of them, that creates a form of interaction among party MPs within the House of Commons that led to this remarkable reversal that the House of Commons in effect forced on the government. The House of Commons didn't, when I say the House of Commons forced it, the House of Commons didn't do a thing. The House of Commons was the forum in which pressures could have that effect. So there's that's good. Now Theresa May and the House of Commons, that was a pathological legislative governance and executive, because the House of Commons was not prepared to back the Prime Minister on the focal policy question of the day, and was not prepared to throw her out. You could describe it by saying that the House of Commons didn't have confidence in Her Majesty's government, but they certainly wouldn't. No, maybe there was somebody who wanted a vote of no confidence, but the vast majority of MPs did not want a change of government. They just wouldn't back the government's policy. Now, if Parliament were the creature of the executive, then that pathology wouldn't have existed. In fact, we don't have, the Prime Minister had no way of solving that problem except by resigning, which she eventually did. Whatever your opinions on the issues of those days, what a model of tenacity and seeking to serve the public. My goodness. And it wasn't going to work because of division. What in the House of Commons? Yes, division in the majority of MPs. So there you go. That was a mess. But eventually the House of Commons is going to sort that out, or the electorate will.
Thank you. Any other? Yes, yeah. Kerry, could you come and help with this?
Thank you. My name's Cameron. I'm currently a paralegal working in public law and public inquiries. So my question, sort of pursuing your point about the dismissal of ministers, is so no to the judiciary, so judicial review. What about within the executive itself? Other entities than the Prime Minister being able to dismiss ministers? I'm thinking particularly about this, the reviews, for example, of Dominic Raab by Adam Tolley, and these ministerial standards, in which one of the key complaints is that the investigations have to be initiated by the Prime Minister and he has the final say, so therefore they are not fair, and whatever Adam Tolley's decision is, the Prime Minister for political purposes could allow a bully to carry on. And then sort of a point following on from that is, would that lead to a ground for judicial review if a report came out sort of showing these issues?
Yeah, for political purposes. I mean, candidly, I think those are the right purposes when it comes to dismissing a minister, and for appointing a minister. But I mean, if I knew more about the history, I just know that I could give you a long parade of prime ministers who have tried to play down misconduct by a minister, and eventually the minister has to go and they resign, or the prime minister dismisses them. So obviously a recurrent pattern, and it's a recurrent pattern because by appointing a minister, the prime minister to some extent stakes his or her own prestige and political future on that minister, and then it's a certain sort of failure for the prime minister if the minister is engaging in misconduct. And I don't think that either judicial review on the issue of whether the Prime Minister ought to dismiss the minister, or even some new form of process as a result of inquiries is a solution to that. I'll tell you what, though, I think that and so my basic point is it should just be the Prime Minister on the hook, responsible for dismissing or not dismissing, and for accepting a resignation, of course, which is often what they do. The Prime Minister should be on the hook, 100% unequivocally. I don't think a Prime Minister should ever be able to say, oh, this minister has survived that process, therefore they're still in my cabinet. No, I think the Prime Minister should be on the hook for the membership of the cabinet and for the entire ministry. But all to the good if there's more transparency, and transparency is really difficult in the context of allegations against a minister, some of which will involve very confidential matters and controversial matters and matters on which it's hard to pass a fair judgment. Well, all of that is up for discussion in the House of Commons and proper matter of questions in the House of Commons. The Prime Minister is accountable for all of that. I just think it could be more useful, and putting the Prime Minister in the predicament that I was suggesting is good for the country. Useful if information could get out in the public earlier and in a responsible fashion. But I guess I wouldn't be in favor of a decision of a new process by which ministers can be sacked by an agency other than the Prime Minister.
Can I raise a question on online, which is this, a simple one. Whilst I'm sure you're right that we couldn't possibly agree on what would be the best constitution, if you were invited to make 3 constitutional changes, what would they be?
Oh, golly, thank you. That's very generous. Oh, golly, you know what? I was going to start. I was going to start reforming the House of Lords, but
one will do.
Yeah, I would. Well, I would start by, as a prelude to a real reform of the House of Lords, which should be focused on its purpose. And of course, what's its purpose? We all think we need a second chamber, but we don't quite know. But as a start, here's a small one. I would change it by the Prime Minister adopting a practice of advising the King on appointments to the House of Lords based automatically on decisions of an independent appointments panel. Or there could be legislation to bring that about. What else?
Well, I think
that's a start. I'll think about the other 2.
Yeah,
maybe they'll come to me as we talk.
Here, yes, over here. Catherine.
Catherine Callahan, barrister and Inner Temple bencher. Given your views about the strengths of the British Constitution, I'd be fascinated to know your views of the strengths or weaknesses of the United States Constitution, so different from our own. And in particular, it strikes me that a lot of the dysfunction that we see in American society right now is the result of parts of its constitution. And I'd be interested in your views on that.
It's not only easier to get rid of Boris Johnson than it was to get rid of King James. It's easier to get rid of Boris Johnson than it is to get rid of an American president. And I think that is potentially useful for the country. But I'm very hesitant, and I'm not going to say that the Americans would be better. I mean, the poor Americans. They they're entitled to go their own way, but they went their own way at a really bad time when Britain offered them no model of responsible executive government. So they needed egghead philosophers to imagine what would an accountable executive, and so it's easy to see how they ended up with what they have. And I'm just not quite prepared to say that they would be better off with a parliamentary executive, because a lot of what makes it work is a matter of political culture and so on. So, but the possibility of gridlock between executive and legislature is less here, although it did happen in during the Brexit process. So, but there's a solution to that problem in this constitution, and that's something that's difficult in the American Constitution. That's one thing. Federalism just makes everything, not everything different, but so much different, so much in how the federal government ought to operate, in my opinion, that it makes it hard to compare. And certainly it is dramatically different from the form of regional allocation of political decision and legislative power in this country. So I'm hesitant to say that they could do better by having a constitution that's more like ours. But I'm certainly they've got problems. But I mean, like Dr. Ambedkar said, I'm not sure you can blame that on the American Constitution.
Thank you. One more here. Thank you very much.
Hi, my name's Alistair. I'm a student here in the Temple. Thank you very much for the lecture. The question I have is about the notion of elective dictatorship, and specifically how that works in a constitution where theoretically Parliament could decide to dissolve itself, and whether you see that as a risk worth taking, I suppose, for the kind of responsible government you've described.
Yeah. Yes. Yes. If you really want a dictatorship, all you need is a sovereign parliament to enact that there should be a dictatorship. Yeah, that's right. Is that a defect in the Constitution? I'm not even sure it's a defect. It sounds like a defect, and maybe we muddle through and it doesn't all go pear-shaped because it would be too embarrassing for the politicians to actually create a dictatorship. I think there's something actually more to it than that. And I tend to think, I'm hesitant about this, as you can tell, but I tend to think that it's not actually a flaw in our Constitution that Parliament could, in law, create a dictatorship. First of all, we have to remember that in constitutions that limit the legislature in such a way that it cannot lawfully create a dictatorship, there are other techniques for creating a dictatorship. You just declare an emergency and suspend the Constitution. So I don't think we should expect that the Constitution will do everything that we need in order to secure responsible government. And then the question is whether the Constitution does secure constitutional responsible government. And it does, as I said, not necessarily good government, but it secures responsible government. Albert Dicey, when he explained parliamentary sovereignty, said that Parliament can pass any law and no other body can override or invalidate acts of Parliament. And in my view, that second point is true, sound proposition of English law, 1885, 2023, and I think not a defect in our Constitution. The first point I think is absurd. The Constitution doesn't authorize Parliament to enact any law. It's easy to imagine laws that Parliament mustn't enact, creating a dictatorship or etc. I'm not, mind runs wild. And there's nothing in the Constitution that says Parliament can do that. What the Constitution does is to authorize Parliament to make law and leave it up to Parliament to decide what law is to be made. And I don't think that's inherently defective, even though, of course, it has the result that if Parliament created a dictatorship, there would be no body with lawful authority to say otherwise.
I'll just ask another question online, which is, in these terms, politicians who require constant policing are indicative of a broken system. Are we witnessing the self-destruction of an obsolete organizational structure?
Well, I don't think it's obsolete. I don't think it's obsolete. I think it's actually surprisingly robust and has been through worse than the past 2 years. And by which I don't mean to underplay anything that you say about pathologies of governance in 2023 or whatever period you particularly have in mind. I do believe what I said in the lecture, that the political danger that the Prime Minister is patently exposed to correlates also with a danger to political party. And I think maybe I have to confess to a little bit of optimism about this. And I don't think optimism is either a political or an intellectual virtue. Far from it. So I'm embarrassed if I'm being optimistic. But this organizational structure, I think, is not obsolete because there's an ongoing potential for the people to decide what is to be done in light of the actual conduct of those who are powerful in the organizational structure.
Thank you. We'll have up to 2 more, then we'll perhaps have time for a drink. Last assumption.
Retired judge. There are some issues, constitutional issues, which the Prime Minister can't be responsible to Parliament for. For example, the formation of a government when no party has a majority in the House of Commons and no party is prepared to join with others to form a coalition, or a decision to dissolve Parliament and call an election when the government has a working majority. Now, in these instances, the theoretical answer is that the king has to act as a constitutional arbiter. In practice, we all know that the king would run a mile before having to make decisions of that sort. Do we perhaps need some body, not the courts, because it's essentially a political decision, but some body which by convention would give binding advice to the king on what to do in situations like that, where no convention applies and where there is no way that Parliament can check the Prime Minister?
That's a brilliant idea. I just don't see how we could get there, how we could, in a fashion that's responsible, create an authority of that kind. And I'm not saying our constitution is perfect. I mean, I think the best we can hope currently is that in a situation of that kind, the working out of politics within the House of Commons would solve the problem. Now, of course, the House of Commons, since the Glorious Revolution and before, it's a bunch of odd bods, and who knows how political forces will work out, and consensus not among a group of 650 people, but among a majority of them, can't be guaranteed, and that's where authority is better than consensus for achieving coordination, and you need coordination to form a government. So there's an attraction in what you say, and I just don't see how to create such how to institutionalize such an authority. What would be the solution if the House of Commons if debates amongst the parties and the MPs didn't result in a situation in which the king could confidently, without having to pass a political judgment on who could form a government, appoint a government. What would happen if the House of Commons couldn't get there? Well, maybe the king would have to stop running. But we're into new territory. And certainly, I mean, if you think about 2010, certainly there, I think, again, here I'm starting to accuse myself of optimism, that the political forces acting on the parties and particular politicians would be significant enough to make them find a way. They'd have to, in a way. I haven't got a solution, and an authority would solve the problem. Wouldn't the authority be like another king, only with actual royal authority of the kind that William IV exercised to determine who should be prime minister? I don't know how we could get there, and it might be easier if the actual king said, "Okay, I better suck it up." And
well, right. Thank you. One more. Do you want to do this one?
Thank you very much. Thomas Langley, bar course student. Thank you very much for your talk. At the other end of the spectrum, I wondered if you had some practical guidelines for judges facing these sorts of decisions. What was, as it were, an over-judicialization, a stray too far into the political, and what really is the realm of the legislature or the executive?
Practical advice to judges? Well, listen to the arguments of counsel and hope they're useful. That's great. That's good advice. And then just remember that the fact that somebody does something that's so unreasonable that no one in their position would do it is not necessarily of concern to your role as of deciding what's lawful and what's unlawful. And so there you go. Yeah, they have to. The judges have to stick to an intelligibly juridical picture of their own role. Do you know? And in this country, we have a doctrine of judicial review for error of law by administrative bodies. In America, in Canada, the judges give administrative agencies some leeway. Not here. It's just up to the judge. Lord Denning, Lord Diplock, they said it's judges do law. We know what the law is. And now the judges do the same thing with policy. And I don't see that they ever even really thought about the implications of this. So today the doctrine is that if a public agency makes a policy and then interprets it, you can challenge their interpretation of their policy, and the judge will substitute his or her judgment as to how to interpret that agency's policy for the interpretation of the agency itself. And it won't be enough for the lawyer for the agency to argue that their interpretation was a reasonable one. It has to be the judge's interpretation. Well, I think it is. It in a situation like that, it is easy for judges listening to the arguments of both sides and acting in the Denning and Diplock tradition to exaggerate the extent of their responsibility for good decision making. But they don't have to. And you know what? I think that in judicial review for error of law, I hope and I believe that judges actually learn a lot from the agency, from the Environment Agency or whatever the agency is, about how to interpret the legislation that the agency is responsible for. So it may be kind of useful that we don't have litigation over the standard of review in English administrative law. But why would the judge substitute his or her interpretation of an agency's policy for the agency's own? So I think judges should be heads up and alert to the possibility that these lawyers are going to over legalize things.
Well, thank you very much. I think we'll call a halt there. Thank you very much for taking all those questions, and I'll ask Master Soole to express our thanks.
Professor Endicott, on behalf of all of us, thank you very much for
hugely insightful and very challenging lecture.
Yeah.
I don't think any of us will look upon the executive formless, as you described it, but certainly not void in quite the same sense as ever again. We're also, I'm sure, all very interested in this idea that one can have responsible government, which is not necessarily good government. And also with the idea that we should have a degree of judicial restraint, if you like. Yet it's a good idea to have people bring hopeless applications in front of the courts so that they can have their day in court to judicialize, if you like, to legalize what are essentially political arguments. After all, we have the example of the United States. The US has a public policy that it's in the public interest, that rights should be vindicated in court, that they should be publicly vindicated. We, on the other hand, in private law, think we should keep people out of court at all possible costs. You must mediate, you must settle, you mustn't get into court. And I just wonder, we might go away thinking how far we ought perhaps to apply that in terms of the kind of litigation that ends up in front of our courts that does actually judicialize what are essentially public submissions, policy submissions, even political submissions. But we will all be grateful to you for the insight that you've given to us into these interfaces and as to the true reason why Liz Truss and Boris have to go. Thank you very much.
Thank you very much.